Arbitration when you're sued for debt by the debt collectors. Brought to you by yourlegallegup.com, your advantage if you are being sued by debt collectors. Some contracts require the parties to give up their normal legal rights to a judge, jury, and legal process and accept arbitration. Arbitration is often confused with mediation, but they are very different things. Mediation is a process of negotiation assisted by a third party, someone else who's neutral, who's supposed to help both sides see reason. Ideally, they then find a fair middle ground and reach an agreement. Arbitration is different. It's just an alternative form of court, a form that involves less of that troubling red tape and expenses that rip-off artists find so troubling. It's a method whereby the parties supposedly choose an impartial third party and some simplified rules and find a way quickly to judgment. No muss, no fuss. You'll have less chance to do discovery or require proof, and the rules of evidence are often relaxed. And when it's all over, it's almost impossible to appeal. It really saves money, see? Because when people litigate, only the lawyers make money. That's what they say. Right. And yet it's pretty much always the richer party that pushes for arbitration or requires it in form contracts. Ever wonder why it's the rich that push for arbitration? How about because when there are documents at all, the wealthy companies that did the wrong are the ones that have them. So reduced discovery really just means you get less of what they have. And relaxed rules of evidence means that they can use documents to prove debt that they wouldn't be able to prove in real court. It's all supposedly fair and spares all that mess and fuss of real judicial process, but really it just speeds up the ripoff and insulates it from appeal, which is handy considering that the debt collectors own the arbitrators, so to speak. Arbitration is almost always done through some large arbitration agency like AAA, which is supposedly perfectly impartial and has the rules to prove it. It's just that the arbitration agencies know that no consumer was ever responsible for causing an issue to be referred to arbitration, so they know who they have to please. The way big corporations have managed to push the Arbitration Act and get it done in Congress is one of the great scams of our time, in my opinion. The way it actually works is arbitration is supposed to be voluntary. You have to agree to be bound by arbitration, although what's voluntary is not always clear by any means. Going forward, you should simply refuse to sign a credit card contract that requires arbitration, or any consumer contract that does, for that matter. To be fair, our opposition is largely for the same reasons its proponents want it. It greases the path towards a swift and decisive decision regarding a dispute. If you're very confident that you have what you need, this might be fine for you. Although we still don't like it because of the inability to appeal and the lack of transparency in the process, as well as the fact that the arbitration agencies typically owe their allegiance to the company rather than you. And considering that the FTC found that one debt collector collected over 80% of its money from people who never owed the debt, a justice-minded person might really question the value of speeding up the process and making it faster and smoother, or the wisdom of doing all of that. If you're willing to fight a debt collector, you have a very good chance of winning in court. This chance goes down in arbitration for various reasons, as we've discussed. For now, however, if you hope to avoid arbitration, you must check and double-check the provision that the bank or debt collector is asserting gives it the right to arbitration. Was there an express requirement that arbitration would apply? Was it clear in an easily noticed print, or was it hidden or buried in the document? It has to be conspicuous. Some courts have ruled that debt collectors cannot assert the right to arbitration. That makes sense when you consider that the unsophisticated consumer would surely not have contemplated violations of the Fair Debt Collection Practices Act by another company when signing the contract with the bank. And FDCPA violations don't really spring from the same conditions as the debt that the contract is supposed to be addressing, so arbitration should not be required. But justice can be blind, especially when the judges are offered an easy way out of a case. They really like arbitration. If you're going to go through arbitration, you should know a few things. First, there will be rules controlling the process, and you need to know those rules right off the bat. Getting those rules and reading them carefully at the beginning is more important in arbitration than lawsuits because the time provided for arbitration is normally so much shorter. You need to know those rules about time. Likewise, understanding the purposes and effects of the debt game played by debt collectors is also extremely important. You will have little time to flounder. If you're going to defend yourself in an arbitration proceeding, you must act quickly. You must learn both your rights and the rules as soon as possible. You won't have much time to learn them. All your substantive rights, i.e. the laws controlling what, if anything, you owe or what they owe you, will remain the same, even if most of the rules of the way the game is played have changed. So everything we've said about answers and counterclaims still holds true. If you can record the proceedings, you definitely should. You want to create as much of a record as possible, even as hard as it is to get it appealed. Even if it isn't our favorite forum, it is possible to win an arbitration, and standing up for yourself always gives you the best chance to win. Defend yourself from the debt collectors. Don't let them rip you off. Please like this video, comment, and share it with others, as these things help other people find our materials. YourLegalLegUp.com